whether in discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. This position is not acceptable because on examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings up that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf of the appellants. My Lord, I'm grateful to my learned friend. My Lord, at para 149, if your Lordship sees at the bottom.
Refer to the constitutional debates.
Yes, the Constituent Assembly debates. Your Lordships have seen it. Now, my Lord, let me return to my note. Please come to para 27. Para 27, my Lord. Additionally, governors are also empowered to act in their discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. It is submitted that the governor's power to act in his discretion under 356(1) and the second proviso to Article 200 would fall under this category. But I've already referred to para 147. Now, please come to 29. Keeping in mind the emphasis of the court in Nabham on the very limited role of the governor, this court's endorsement of the report of Justice Punchi Commission was only to the extent that it cautioned against the grant of wide discretionary powers to the governor at the expense of the real executive, namely the Council of Ministers. Now, my Lord, I have taken the submissions so that your Lordship see, and my Lord, I say so with great respect to the learned Solicitor General. My Lord, he argued this case with extraordinary industry. I say so with great respect. It is respectfully submitted that there is a divergence between the submissions made by the learned Solicitor General on behalf of the Union and the law as laid down by this court. This divergence is being pointed out to assist this court and not based on any instructions. In respect of the role of the President, the written submissions of the learned Solicitor General contend, relying selectively on the writings of H.M. Gavai, it is suggested that the President of India may in certain circumstances in his discretion dismiss the Prime Minister and the Union Council of Ministers or dissolve the Lok Sabha. It was contended that these powers also extend to the governors. That the President may in his own wisdom determine whether to assent to a bill reserved by the governor for his consideration. That the President may act in his discretion in making a reference to this court under Article 143. It is stated that the President, if he so wishes, can always in his discretion further refer the matter to the Supreme Court for its own opinion. That the President and the governors ensure that both the central and state governments operate within the parameters set by the Constitution, balancing autonomy with oversight. My Lord, there is, with respect, my Lord, it is not correct. The President and Governor, my Lord, do not have oversight over the Honorable Prime Minister or the Chief Minister. I thought, my Lord, it must be clearly stated These submissions are not correct. It is respectfully submitted that submissions advanced on behalf of the Union in respect of the powers of the President do not accurately reflect the law as laid down by this court in Shamsher Singh. They are also contrary to the express words of Article 74(1) of the Constitution. It is submitted that the President of India, who is a constitutional or formal head of the Union, must perform his functions on the advice of his Council of Ministers. While the proviso to Article 74(1) enables the President to require the Council to reconsider its advice once, he is obligated to act in accordance with the advice tendered after such reconsideration. The President is not empowered to act in his discretion while making a reference to this Honorable Court under Article 143. In any case, there is absolutely no question of the President in his discretion dismissing the Prime Minister, other ministers, or dissolving the Lok Sabha. Any such construction.
That is not his argument. He says that
No, my lord, I have gone by his written submission.
Yes.
I want your lordship.
So, so
The President is bound by the aid and advice.
so far as President is,
My lord, I only went through his.
the learned solicitor distinguishes President and Governor. According to him, the President is bound by the aid and advice of the Cabinet,
My lord,
not the Governor.
My lord, I have taken an effort to read the submissions. Whichever portions are not consistent, I'm just pointing it out. And my lord, I'm doing it with a great deal of deference, respect, and admiration for the learned Solicitor General. But my lord, it's my duty just point out so that it's accurate. That's all. My lord, if you think there is an error in his submission, you must attribute it to me. I'm senior to him. You must attribute it to me. I must be the one to take it on my shoulders. My lord, these are some privileges. I hope the Solicitor General doesn't take.
No.
My lord, please come to para 35.
You are not as friendly to him as Dr. Singhvi and Dr. Mr. Kapil Sibal.
I don't know who's more honest. I don't know who's more honest.
We can't answer that.
As far as the role of the governor is concerned, the Union has submitted that the governor acts as a representative of the President and exercises executive powers of the state on behalf of the President. However, it is also submitted that the governor discharges his duties as a statesman, unaffected by the political composition at the center or in the state concerned. That the governor is the agent of the center who will guard the center's policy. This contention is based on a speech in the Constituent Assembly. That the governor's power to summon and prorogue the state legislature is a legislative power. It is suggested that these powers can be exercised by the governor in his discretion. It is submitted that the governor does not act as a representative of the President or an agent of the center. The governor swears an oath under Article 159 to devote himself to the service and well-being of the people of his state. This commitment clearly indicates that the governor is intended to act in the interests of the state. Insofar as the Union's policy is concerned, the same is adequately protected under Article 256 and Article 257(1). Additionally, in respect of the state's power to make laws under List 2, the states enjoy executive and legislative power conferred under the Constitution. The wide range of discretionary powers that are identified in respect of the governor are contrary to the judgments in Shamsher Singh and Nab. Lastly, it may be noted that the Union's submissions have the effect of resurrecting this court's judgment in Sardar Lal, which was unanimously overruled in Shamsher Singh. The Union of India has highlighted the functions governors perform under Articles 154, 163 to 167, 165, 233, 234, 243K, 316. Well, I've referred to all of them. These are referred in the written submissions. In the context of these provisions, it has been argued that while these functions may sometimes be formal and facilitative and rooted in aid and advice, some discretion is key to protect constitutional governance, federal balance, vulnerable regions and groups, and the continuity of the state. Well, this is what I'm saying is not accurate. In other words, it is contended without foundation that governors may possess discretion in appointing the Advocate General, summoning the state legislature, addressing the houses, making a special address to that legislature, assenting to bills, making decisions concerning the disqualification of members, the laying of the annual budget, and appointing district judges, appointing members of the state public service commissions, granting pardons, and promulgating ordinances. The union also argues that the governor has enough discretion to effectively veto a bill by simply withholding a bill without returning the bill to the House for reconsideration under Article 200. Based on the law laid down in Samshay Singh, it is respectfully submitted that this argument of the union in support of an absolute power to veto will render the state elections completely futile. These submissions are contrary to the letter and spirit of the Constitution. Now, my lord, I come to 200. The Constituent Assembly debates firmly demonstrate that the founders intended the governor to only be a titular head acting on ministerial advice. Article 200 was derived from Section 75 of the Government of India Act 1935. However, unlike Section 75, which gave the governor express discretion to assent, withhold, or reserve a bill, the expression in his discretion was deliberately omitted from Article 200. Dr. Ambedkar in the Constituent Assembly debates on 31st May 1949 had clarified that the role of the governor was purely ornamental. My lord, I must say, with respect, I truly admire the industry of the learned Solicitor General. He put Government of India Act 1919, then he put 35, then he put the Rao Committee, the drafting committee. But my lord, this is a new constitution. It is a break from the Government of India Act 35. So the discretion which is enjoyed under the 1919 Act or the 1935 Act must not actually creep into the interpretation of the Constitution. Then, my lord, para 45. The governor is not conferred with any discretion by or under the Constitution in relation to Article 200. Under Article 200, the governor is bound to act in accordance with ministerial advice while deciding whether to A, grant assent, or B, withhold assent for the purpose of returning a bill to the House or Houses for reconsideration, or reserve a bill for the President's consideration. The sole exception is found in the second proviso to Article 200, which entitles the governor to exercise discretion in reserving any bill for the President's consideration if, in the opinion of the governor, the bill would derogate from the powers of the High Court as to endanger its constitutional position. Now, my lord, the next point is whether this power to assent is a legislative power. Assent by the governor under Article 200 is not a legislative power. The governor is a part of the state legislature under Article 168. However, the assent of the governor under Article 200 is not a legislative power. The act of assent is also quintessentially an exercise of executive powers of the state, which could have characteristics of a legislative act. My lord, he is the head of the executive, so he also acts as the head to declare a bill to be a law. My lord, that declaration in Article 200 is to declare. My lord, what do we mean by law declared by the court? A bill is declared to be a law by the assent of the governor. Chapter 4 of the Constitution specifically provides for the legislative power of the governor. The sole provision under this chapter is Article 213 relating to the power to promulgate an ordinance. Pertinently, even the legislative power to promulgate ordinances is exercised on the aid and advice of the Council of Ministers. The 7-judge bench in Samshay Singh clarified that all other powers of the governor are executive powers even if they partake of legislative or judicial actions. Articles 200, 201 fall under the subheading of legislative procedure under Chapter 3. A bill needs to be approved by all components of the state legislature to have the force of law. Since all executive power of the state is vested in the governor, under Article 154, the governor's assent represents his imprimatur and certification on aid and advice in relation to a bill passed by the legislature. Even though governors are a part of the legislature, Article 158(1) expressly precludes them from being a member of the House. They are not entitled to participate in the proceedings and affairs of the House. They do not have a right to vote or participate in deliberations. The right of the governor to address and send messages to the House under Articles 175 and 176 are exercised only on the aid and advice of the Council of Ministers. Similarly, the governor's powers under Article 202(1) and 207(1) are also exercised on ministerial advice. This unique relationship between the governor and the legislature has been explained in Valluri Basavaya and State of Bihar versus Kameshwar Singh. Thus, while the governor's assent under Article 200 forms a part of the legislative procedure, it does not constitute legislative power that may be exercised independent of ministerial advice. It is therefore most respectfully submitted that the submission of the Union that Article 200 confers a legislative power upon the governor is liable to be rejected. The text of Article 200 makes it evident that the governor must follow one of three courses of action. It is no longer res integra that a governor must exercise one of only three courses of action under Article 200 under the aid and advice of the Council of Ministers: grant assent or withhold assent for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent or reserve a bill for the President's consideration. This Honorable Court has, on at least 5 separate occasions, held that the substantive part of Article 200 mandates that the governor shall exercise one of only 3 specified courses of action. In case of withholding of assent, the governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him after reconsideration by the legislature. My Lord, there was some emphasis on the words that the governor shall declare. But my Lord, that declaration does not have an independent meaning in that article. Declare means you do one of these 3. It is a form of action. The word declare, my Lord,